So our webinar today would mostly talk about what are the most common issue that you would face when renting property as a landlord or as a tenant. And I'm just going to pass it on to the next slide. So this is just a slight introduction of myself. I'm Evveline, so I was admitted I was admitted to the bar in 2019, as a solicitor, and joined Lisa's Law in 2020. I have worked in litigation for many years, and the cases I've usually deal with is landlord and tenant, commercial disputes, corporate disputes, employment, or any common contractual disputes. So I speak 5 languages. So our law firm, we do other area of law, such as contract disputes. We have property division here. We do divorce, estates, debt collection, personal injury, any other disputes. We all covered such area. Okay, just gonna go down here. So let's just quickly go through what are the common types of tenancy agreement in the UK. So in the UK, what we commonly see, it's what we call assured short hold tenancy agreement. That is very, very common. While the other 3, you don't see it that often. It's the excluded tenancy or license. This sometimes you do come across. Assured tenancies, you don't usually come across anymore. Regulated tenancy, you don't usually come across anymore unless you are people on benefit. But generally, you will be looking at the assured short hold tenancy agreement. So the assured short hold tenancy agreement, what makes it AST? We call it in short. AST agreement is usually an agreement between the private landlord and the tenant. The tenant usually is given a guaranteed short-term tenancy agreement. It can be 3 months, 6 months, it can even be monthly. So usually such tenancy agreement will have to commence on or after the 15th of January, 1989. Anything predates that will not be AST. And this place that the landlord is renting must be the tenant's main residence. Rent payment on a regular basis, such as weekly payment, monthly payment, it can be either to the landlord or to a managing agent. As for what usually does not constitute an AST agreement, if the rent itself is more than 100,000 a year, or if it's less than 1,000 in London, or 250 a year outside London. As for tenancy agreement that commence or agreed before 15th of January 1989, it will not be an AST as well. Holiday lets, they're not AST. If your landlord is the council, it's not going to be AST as well. Business leases or tenancy for licensed premises, they are all not AST. And what are the other, sorry, the title is, it's not correct. It's not other AST, but what are the other type of rental agreement that you have outside, which I just mentioned. So regulated tenancy, you don't see this that often anymore, but they are commenced before 15th of January 1989 under the Rent Act, the 1977 Act. Such properties are usually rented by the housing association or housing trust. That's why I say you don't come across it so often. These sort of tenancy agreements are way more protected compared to just the common AST. So why do they have more protection? Because even for eviction, unless the court order, there's no way you can actually evict them. And if the tenant were to die, his spouse or actually even their the people who've been living there, let's say their children, usually they will have such thing as a right to take over. And they're allowed to apply for a fair rent. So let's say if the landlord, which is the council, the housing association, were to increase the rent, they could actually challenge the rent. Other than that, they enjoy housing benefit, and the landlord is responsible for all repairs. And what is excluded tenancy or license? This is fairly common. We call it maybe occupiers. They are the people who share the accommodation with a landlord or licensor, or any of the family members of the landlord or licensor. Such agreements usually immediate before, well, actually such agreement can be agreed immediately before the tenancy or license was granted. And that time when it's being agreed, if it's a landlord's main home, that it will become an excluded tenancy or a license. Things like the holiday lets, these are also excluded tenancy. They are what we call occupiers, right? Usually it can be rent-free. So they can actually pay surveys in lieu of rent. Let's say if someone is taking care of the property, they are not generally tenants, they are occupiers. Let's say if they're house sitters, they are dog walkers, or someone who is house sitting, they're usually occupiers. Other than that, the other three, it's not that common, but asylum seekers, home office people who have been issued a no right to rent notices, or the other type would be hostile licenses that are granted by public bodies. They will all be excluded tenancies. As for assured tenancy, you rarely come across this as well, because it has to be granted between 15th of January 1989 and 28th of February 1997. They are very well protected as well. They're protected from eviction unless a term of the tenancy agreement is breached. They have a right to succession, which usually you don't have in the AST, and the rent cannot be increased unless it's being agreed. And if it's disputed, the tenant has a right to appeal. So what are the other things that you have to consider before renting? This is actually quite important, because we came across many clients who did not pay attention to some of the clauses, what are their rights, and they ended up sort of being bullied by either the landlord or the agents. So what are those things that are actually under the landlord's responsibility under the AST agreement? So the landlord must usually focus on things like health hazard. The property has to be safe and well protected. Okay. The next thing is for gas and electrical equipment. These have to all have what we call a certificate of safety. They usually have to hire what we call professionals who could issue a certificate for this, and they will have to run regular maintenance. Furthermore, things like the record of inspection, these has to be the paperwork has to be done and given to the tenants beforehand. Smoke alarms and carbon monoxide alarms, these are very important. Without that, they're not allowed to rent. Energy performance certificate. At the moment, it stands that all property has to be at least E for all the new tenancy agreement for the land, in order for the landlord to actually rent the property out. Energy performance generally means if the property is very cold, usually it means that it doesn't actually meet the requirement. So you can actually ask your landlord for a copy of the EPC, we call it in short. The last but not least is if a landlord were to evict you, if you're protected by the AST, then they will have to serve a Section 1 or Section 8 notice. Without that, it will be illegal eviction. And for deposit, this one usually raise questions because we have clients who never put their deposit into the government approved scheme. So for landlord now, you have to put it in the government approved schemes, and there are three provider that is approved by the government, which is Deposit Protection Service, My Deposit, and Tenancy Deposit Scheme. The landlord must also send you a document called How to Rent. And the landlord will have to carry out checks on the tenant to see if you have the right to rent. And last but not least, if the landlord is renting out to 3 people, not from the same household, not from one single household, the landlord will require what we call a House of Multiple Occupation license, which is a HMO license. Without that license, it's actually a criminal offense for them to actually rent it out, and the council could usually take an action if you report it to the council. We have a link below in the slides. You can see that is the How to Rent document. You can actually download it directly from the slides. Okay, next. So as for excluded tenancy, which you do sometimes come across. So let's say if your son is staying in your property after 18, do not take rent. They are occupier, you can actually kick them out anytime. But in that sense, what are your duties if you're a landlord staying with someone who is an occupier, excluded tenancy or licensee? So if the property is rented by at least 3 people and not from the same household, again, you will still need a HMO license. The property condition must be generally fit for human, safe to live, free from any health hazard. This is a common one. Gas safety check every 12 months. The next one is very important, fire safety. So all the furniture and decoration has to meet the manufacturing requirement. There must be this fire safe certificate label on all your furnishings and decorations. For appliances, it has to be all in safe working condition, and for fire alarms, it must all be in working order. So what else? So during the license period, this is quite important. So for occupiers, usually, unless it's mentioned in the agreement, the landlord is generally not obliged to repair any damage because you're an occupier, and they could actually deduct it from your deposit. For excluded tenancy, deposit is not required to be put into a scheme, the deposit scheme. So the landlord can actually hold on to the deposit. As for the annual gas safety check, it still has to be carried out. Tenancy agreement, whatever that's drafted, has to comply. You have to comply with the agreement. And yeah, the last one I've actually mentioned it, which is the deposit scheme. It doesn't have to be inside. So for the excluded tenants and license, it can be terminated usually just with a note. We call it a notice to quit. So either party can just serve a notice to quit. But the problem with that is if you are on the notice period depends on how often you pay rent. So if you're paying monthly, the notice period will usually be monthly. But that is for the general AST, if it goes on to periodic. But for excluded tenancy, reasonable notice is sufficient, doesn't require a court order, you can kick them out anytime. So many of you is not aware of this. It's not new anymore, but it's still relatively new. But the Tenant Fee Act 2019. So the Tenant Fee Act, what is it? The Tenant Fee Act itself, it's a document that you can actually find on the government website. It allows you to know what is the right for the landlord and the tenant within the document. And the government has actually listed out quite an extensive amount of clarification as to what sort of fee that can be taken by the government, from the estate agent or the landlord, and what is actually prohibited. So I'll start off with the deposit. Sorry, can someone mute? Yeah, thanks. So for deposit, you're usually allowed to take up to 5 week rent. This is what the government have decided. However, if it's more than 50,000, then you can actually take it up to 6 weeks rent. And deposit, again, have to put in the government scheme. As for holding deposit, the holding deposit maximum is £50. But if your property being rented is very expensive, they might be able to charge a reasonable fee if higher. Changes to tenancy agreement, if there is anything that has to be changed in the tenancy agreement, let's say your partner wants to move in, you have to change, they can actually take a fee and it will be kept at £50 when requested. And they could actually have the discretion to charge higher if there's more to do. And things like early termination, which some tenants might exercise their right to early termination. So the landlord may charge an early termination fee. So it's not wrong for the landlord to charge, but these must not exceed the financial loss incurred by the landlord to allow the tenant to leave earlier, or whatever fee that is reasonable being incurred to arrange as such. Payment of utilities, it is the tenant's responsibility to pay bills according to the tenancy agreement. However, some agreement, we do know that it does say inclusive of all bills. In that case, then that's fine. For late payment of rent, generally, if the rent is being paid late for 14 days, sorry, what happened to the slide? Apologies. Okay, late payment, sorry. So late payment of rent, usually if it's 14 days, and any replacement of keys, they're allowed to charge such fees. Yeah. But anything that they charge should not exceed 3% of the bank prime rate. So things to pay attention when you are signing or before you sign a tenancy agreement. So I think this is quite important because if you are, some tenants have special requirements. So I think you should pay attention to the tenancy agreement before you sign it. Example, if you're a smoker, you want a pet, make sure that there's a special term that covers such an agreement. The other one would be security deposit. How is it being handled? And whether the deposit covers any repair. So for example, if there's a repair that is required, whether the landlord will deduct it from the deposit, what sort of agreement has been reached, whether as a tenant you can sublet the property, because I've seen a lot of students, or actually mostly students, they tend to leave a bit earlier compared to what they have signed up for, and then they would just sublet the property. Many of them did not actually receive or actually seek permission from the landlord. So that itself is an issue. Next one would be who pays for the repair. Like I say, minor repairs, who pay for it, whether you're allowed to do DIY. Some landlord will, usually in the standard AST, it will be stated if there's any repairs required, you have to inform the landlord or management company because the landlord will usually carry out such repair. But sometimes we do see landlord agreeing. They will ask the tenant to pay out of pocket and then they will reimburse the tenant. So it's not rare. So what is the tenant fee ban all about? This, just to make sure that no prohibited fee shall be in the contract. If you've seen such clauses in the contract, you should actually point it out and ask for it to actually be removed. And are utilities included in the tenancy agreement? Like I say, some of you will agree that everything is included. Usually if you rent rooms, sharing with other tenants, you will usually have all bills inclusive. If a tenant wants to leave the property, how much notice does the tenant have to give? these are important clauses. We call it termination period, notice period. Yeah, usually you will have one in the contract. If there's none, it's going to be problematic. We've seen it so many times. If there's one, then you have to follow the termination notice period within the contract. So can I change my tenancy contract term? For example, you may want to have a pet to live with or partner. This is what I mentioned just now. So after what I've said, I would like to bring to your attention what is the common problem that we usually get from our clients. So one of the bigger issue, we don't see this, actually correct myself. We actually see this quite often, but the ones we usually do is 3-bedroom house, 5-bedroom house, no HMO license. But this case that we have here is the owner did not have necessary HMO permit and planning permission to operate her rental property. Her rental property has 21 rooms. And usually for 21 rooms, it's not just HMO license that you require. You require actually a planning permission because it will be sort of like a hostel now. So what happened is if the council decides also, sorry, other than that, if your area, the council decides to remove what we call the Article 4 right and enforce the so-called Article 4 rights. So when you want to rent it out to anyone that's more than 3 who are unrelated individuals, then you will have to apply for planning permission as well. It's not just because it's more than, for planning permission, if it's more than 7, you will require planning permission. Other than that, if there's Article 4 restriction, then you will have to apply for a planning permission as well. So what happens if you don't have a HMO license when you rent out your property? You could be fined up to 20,000, and that's a hefty fine to actually be fined in such circumstances. Because we have seen, even from case law, usually the court will not fine the full sum, 20,000, but generally the court will take the side. They will definitely give you a fine, but it's up to the discretion. But I've seen from the range of 5,000 to 15, 20,000. I don't think they enforce it that much, but unless it's a really, really bad breach, maybe the property is in bad condition or something like that, then maybe you get a 20,000 fine. As for the other one would be a Section 21 notice problem. Many of our clients who actually come to us, they would like to issue a Section 21 notice when the agreement comes to an end, and also because the tenant hasn't been cooperative. The problem with Section 21 notice is very strict. The court has a few very stringent rules even before you can issue a Section 21 notice. So what is required in place before you can even issue a Section 21 notice? The landlord has to, prior to tenant move in, provide the tenant with what we call the EPC, Energy Performance Certificate, how to rent guide, gas installation certificate, best also have the electricity one, and the 4th one would be whether deposit is in the deposit scheme. If the landlord failed to do the above 4, it's unlikely that you can issue a Section 21 notice. You can actually correct it after, but it has to be done before the Section 21 notice being served. Okay. So there is this new update. I'm not sure how many of you have actually seen it. It's called a no-fault eviction to be banned in England. I think this is quite huge news, just 1 or 2 weeks back. It has been ongoing, but yeah, recently there's update. So this is not enforced yet. The legislation is not fully developed or out yet, but what we will be seeing is the government is taking a position to have no fault eviction. So they will not allow landlords to ban families with children or those who receive benefit, because it's very common when you look for property to rent that it says prefer not, well, most probably they always say no couples allowed, no families allowed, no DSS, which is people on benefit. And this is not allowed anymore. You can't actually do that as landlord, okay? At the moment, it's not enforced yet, but in future. They will be ending the use of arbitrary rent review clauses. Tribunals are restricted from hiking up rents, and tenants to repay rent for non-decent homes. This, I think the last one would be quite important because, especially in London, many parts of the property that's being rented, we have seen clients complaining where boiler is not working, mold, damp issue, everything is on, the house is like falling apart. We have seen clients with those situations, and I think this is actually a pretty welcome position, because if the property is not up to a livable standard, I think the tenant should actually be repaid their rent. Tenant has the right to request for a pet. So now pets, if you look at a lot of the advertisement out there, it will always say no pets allowed in the house. Anyone with pets will not allowed to rent this property. But moving forward, they will allow tenant to have the right to even request for a pet in the house. You can't say no pets allowed, and the landlord must consider it, and you can't unreasonably refuse it. Not sure how this will be going on moving forward, because using the term reasonably, unreasonably, it's a very technical term. What is reasonable, what is unreasonable? It's going to cause some problem here. The next one would be all tenants to move into a single system of periodic tenancy. This has its good or bad, because so all tenants will be under periodic tenancy rather than a fixed term. In that sense, tenants can move out of property easier without having issue. But I can foresee the other problem would be the landlord might have difficulty securing tenants, because if the tenants can move in and out anytime, then that will be an issue itself. But we'll see how it develops after. A tenant will only end if a tenant ends. A landlord, if has a valid reason. So I'm not quite sure how, sorry again, this is getting a bit annoying. 1 second. So yeah, I'm not sure how, where the landlords are welcoming this this new law itself. And after that, rent increase notice will be doubled. So any rent increase, landlord has to give you double the time to consider. And the tenants now has a right to even challenge the notice itself. So the landlords, the tenants are being given a lot more control and power. I guess after COVID-19, there was a huge surge in eviction proceedings, and the court is actually having a lot of backlog at the moment. So you mostly see your eviction being dealt with in a six months or more than that. So I guess that's why they're trying to improve the eviction proceedings. The councils are granted greater powers, and they're allowed to even increase fine for serious offences. Private rentals ombudsman will be established, which I think is a good thing. It will be quicker and low cost, because at the moment, well, for eviction, for most tenants and landlords, it can be quite expensive. Protection to landlord to gain possession of your property efficiently, only if it's for antisocial behaviors, and also if they want to sell the properties, which I can see a problem as well, because most landlord might just use the reason that they want to sell the property, and they might want to evict the tenant. We'll see. There will be a new portal. So this portal will be set up to educate landlords and tenants as to what are their responsibilities. And I think that's actually very helpful. So some of the common questions that I would like to point out that my clients have been asking. So 1 second. So what is the maximum holding deposit the landlord or agent could take? Will holding deposit be deducted after? So holding deposit usually can be taken if you want to reserve a property that you want to rent. So for holding deposit, it's usually only taken for a week's rent, nothing more than that. And once you're ready to move in, you can simply request for a refund of the holding deposit. Or if you really plan to stay on, you can agree to have it deducted from the first month's rent. If you want a refund, then just make sure that such refunds request is asked within the 7 calendar days of your lease, of the tenancy agreement start date. Okay, and next one, whether an upfront fee of 12 months rent is agreeable. We have seen many AST outside where they take a 9 months upfront or a 12 months upfront. Well, to be fair, there's no legal limit around such upfront rent. It can be collected anytime and however much. The problem that we see with this is we wouldn't advise to pay such, especially 12 months upfront. The reason is, even if there's a break clause or even there's a proper reason for you to actually terminate your contract, we always see an issue whereby the landlord or the agent refuses to refund the upfront fee. And what happens then? You will have to use a lawyer to go seek the money back, which is counterproductive. So I wouldn't advise for people to actually sign up for 12 months upfront. So what is a periodic tenancy? So I've mentioned it just now, just by passing, but periodic tenancy happens when your fixed term, which is, let's say if you have a 6-month AST or a 1-year AST, once the fixed term has passed, then it becomes either you sign a new contract or it automatically becomes a rolling tenancy agreement. So the proper definition is a tenancy that is on a rolling basis with no fixed date. So what happens when there's a periodic tenancy? The periodic tenancy, let's say if you want to leave or you wish to terminate your periodic tenancy, the notice that you have to serve is minimum of 28 days. But generally, if you are paying rent monthly, or let's say quarterly or half yearly or 1 year, your notice period depends on how often you pay your rent. So if you pay your rent monthly, notice period will be 1 month. If it's half yearly, notice period will be 6 months. So when you rent AST, usually the agent or the landlord will carry out what we call an inventory check. There's no law to govern that. It's not compulsory. However, this is usually for the protection of the landlord. I would also say it's a protection for the tenant, but we'll see how I explain that. So it's usually for the landlord because if there's no inventory checks being taken before the tenant move in, the landlord is usually exempt from even claiming any damages. So when the tenant move out, if you say that the tenant make a scratch on the wall or they scratch your floor or paint came off or the toilet bowl broke, it's very difficult for you to actually claim that the tenant actually caused it because there's no inventory check. You can argue that there were photos before and after, but it's very difficult to sort of pinpoint that at what period of time, unless you have photograph like of the property before you rent it out, maybe it can still be a valid one, but I'll still say better to have a inventory, like proper inventory checklist, so that if there's anything that you want to claim with the tenant after, it'll be good. As for the tenant, I have seen issue where the tenant come to us saying that they did not break this, the landlord is asking for the money. My usual advice would be, it would be the landlord to produce evidence. But I know some landlords do bring proceedings just because of this. And what they generally do, even if there's no inventory check, they will rely on photographs during the advertisement. And they would say that that was caused by the tenant. And in that case, the tenant would also usually be protected if there's an inventory checklist, because at least everything is black and white, and there wouldn't be anything disputed. But yeah, so usually in most circumstances, the burden of proof will be on the landlord to prove that such repair, if any, such repair will be necessary, and it is the tenant who caused it. And any of such repair will usually be deducted from the deposit scheme that's holding by a third party. So what are the tenant general protection in the UK? I mentioned this before, we're just going to go through it briefly. So the tenant in the UK are fairly well protected. I just realized most of them just don't know their rights in the UK. So it is the landlord's duty to provide a place that is safe and well maintained. And the landlord has to return the deposit at the end of the AST. The right to challenge if there's excessive fees, because you're protected by the Tenant Fee Act. And then you need to know who's your landlord, because in many circumstances, we do realize that either there's an agent, a third party, who's sort of liaising with the tenant, and the tenant don't even know who's the landlord. Right to peaceful enjoyment of the property. So the landlord can't just give you a notice 24 hours and turn out the property, because you as a tenant has the right to peaceful enjoyment. If the landlord does that, the landlord will constitute a trespass, unless it's an excluded tenancy or a license. That's different. Check the property's energy performance certificate. This is quite important, because especially electric bills is soaring and gas is soaring, everything's soaring. The EPC performance certificate, it will sort of give you a guidance whether the property is very well insulated. So a very well insulated property will usually get an A-rated EPC performance certificate, where it retains heat. The whole building itself is very well built. For most ex-councils, UGC generally D, E, they're not very well insulated. That's just the nature of the property itself. So the next one would be, as a tenant, you'll be protected from unfair eviction and unfair rent. This is arguable. You are protected, but what happens if the landlord tries to unfairly evict you? The problem with this is you will have to find someone to assist you, either a solicitor, or you can challenge it if you know how to do it. But I would best advise, if you're a tenant, there are a lot of association outside who can help, especially the Citizen Advice Bureau, Shelter. If not ourselves, we do protect tenants as well. Have a written agreement if you have a fixed term tenancy agreement of more than 3 years. Other than that, I would think that every time you rent, not just more than 3 years, you should actually have a written agreement, because it doesn't really matter if you are excluded tenancy agreement or a license agreement. Best have everything written down just to protect yourself. And any such agreement should be fair, and it has to comply with the law, because, well, if not, the agreement will be void anyway. So how do you solve a dispute with a landlord, especially things like deposit deduction, cleaning costs? Always start off with negotiation. I mean, solicitor will be the last resort, to be honest, because it's not worth the money if you are able to resolve it with your landlord. But most of the time, I know you can't resolve it. That's why it ends up going to the solicitor. One of the most important one I've seen quite commonly is the deposit. Many landlords did not put it in the deposit scheme. What happens with that is, rightfully speaking, if you did not put it in the deposit scheme, if you have taken a deposit, you can actually be liable up to 3 times, 1 to 3 times of the deposit amount paid, they can actually sue you for that. And the court will usually minimum will return the tenants 1 time the deposit. The maximum is 3 times, so it can be quite hefty. And if there's any deposit dispute, you should usually go through the adjudication procedure, whereby the government scheme actually offer it before you actually go to a solicitor. That will actually be the easiest to deal with. Cleaning fee. I know many contracts I've seen, tenancy fee, tenancy agreement, they have such clause, professional cleaning requirement or professional cleaning fee included. Actually, Tenant Fee Act bans such cleaning fee, especially professional cleaning fee. I mean, you can clean it yourself. It's not necessary for a professional to clean it. So if there's a clause like that in your agreement, you can just point them to the Tenancy Fee Act. This is actually banned. But general cleaning, yes. When the landlord gives you the property in a very good condition, you are generally told to actually return the property in the same state. So if you do not return it at the same state, then sorry, could you mute yourself? Okay. So okay, sorry. So yes, generally you should actually not see such clause in your agreement. So if the landlord really refused to negotiate, then yes, you will have to issue a pre-action letter. These sort of pre-action letter, it's quite simple. You can actually find templates online. And all you have to say is, where's my deposit, this amount, please return it within 14 days of this letter. That itself serves as a pre-action letter. And then after that, you can take the matter to the court or instruct a solicitor. So I think I've covered most of the common questions. Oh, okay, sorry. So next one would be a Q&A question session. So let me just see if there's any question. Sorry, Shannon, where can I see the questions?
Yes, what question you mean?
So now it's the Q&A. Is there a Q&A section or?
Yeah, there's a Q&A section. So if any of you have any questions, feel free to pop your question in the chat box. So you can just type your question here and Evveline will answer them. Or you can also unmute yourself and just voice out your question.
Yeah, you can just unmute yourself and voice out.
So if you can't think of any questions right now, well, you can always email us later. Oh, we have a question from David.
1 second. Where's the question?
It's a direct message. Let me just share it.
It's a direct message. Okay, just share it. Yeah.
You got it?
Okay, yeah, I can see it. Okay, the question is, if a person is holding a Type C tourist visa, can he or she sign AST for 3 years? So the answer is no. So before you rent it to someone, you have to see if they have the right to actually stay in the UK. If they are holding a tourist visa, then they can't actually sign an AST for 3 years. I hope that sort of answers your question. Okay, is there any more questions? So Shannon, are you getting any more direct questions?
Yes, so David replied,
okay.
Well, let me just share it to everyone.
Yeah, I think, can you just share it to everyone? Oh, sorry, did someone scribble on the
Wow.
I'm sorry, guys, that is a technical problem. But okay, someone mentioned how to terminate the contract earlier than the agreement without any fine. Good question. How to terminate the contract earlier than the agreement? So this is a good question. The only way for you to terminate the contract earlier is to have a termination clause or a break clause. If there's no such clauses in your contract, it is going to be difficult. You have to find issue with the tenant. So let's say if the tenant, well, I think I'll put it simple. If there's no termination clause, and it is an AST agreement, I'm assuming this is an AST agreement, then you can't actually terminate it because the tenant is protected. But what you can do is if the tenant if the tenant has breached any contract, let's say antisocial behavior, did not pay rent, destroy your property, you can bring a Section 8 notice, and that's how you can sort of terminate it earlier. But even then, it's not much earlier because once you send a Section 8 notice, it depends on what, which grounds you're going to bring it. This is a whole separate topic itself, but it depends on which ground you bring the notice in. And it will itself have separate notice period. After that, you have to issue eviction proceeding to the court, which is now taking about, I think, 3 to 6 months at least. The court is not dealing with it very quickly, unless it's antisocial behavior. Okay, I hope I answer your question. And from David. Okay, wait, so David says, okay, sorry, so he wrote the full question now. For a person holding type C tourist visa, as a landlord, can I let the property to him or her by signing a contract which clearly states he or she can live here 180 days a year, which is the same as what the visa stated? So it's the same as what the visa stated. I believe what you actually need, David, it's not a tenancy agreement, because this person is holding a tourist visa. What you actually should provide them is it's a license agreement, which is the excluded tenancy one, because you can't actually give that person an AST. They are not resident in the UK per se. Usually when a landlord rents out a property, you have to see the status of the person. If the person has no right to stay in the UK, you can actually rent it out to them on an AST basis. In your situation, the person is a tourist visa. So tourist visa, the property you're renting would be what we call as a sort of like a holiday let for a certain amount of time. So that itself, I think best if we just go forward with a license agreement. Okay, how can we take, tenant to the court? Oh, how can you take tenant to the court? Well, this is a very broad question because it depends on what is the reason you want to bring your tenant to court. Can Hannah, do you mind if you can either speak to me or you can write it out, because I don't know what's the reason you want to bring a tenant to court. You can always bring a tenant to court if there's antisocial behavior, not paying rent, destroy your property, breach of a term of the contract. You can actually obviously, bring them to court for those reasons. But if there's no reason, you can't just bring a tenant to the court. Yep. Yeah, so Hannah, if you can just add your question. Okay, that's fine. You will speak after. Okay. So is there any other question? No worries. Thanks, Hannah.
There's one question with a direct message to me. I'll share it here.
Okay, perfect. You can share it in the group.
Okay.
Okay, if the tenant files a complaint to the council, could the landlord end the periodic tenant agreement? after or during the during the fixing the identified mistake. Okay, I'm assuming what this person is saying is there must be an issue with the property and the tenant filed a complaint to the council. And now the landlord would like to end the periodic tenant agreement. Okay. This is a tricky situation, which I would then advise you to end the periodic tenancy agreement now, unless the tenant has breached has made a very great breach on their end. The reason being, if they already filed a complaint to the council, it depends if the council has already taken notice of it, because end of the day, the council might view this as illegal eviction if you try to kick them out. But if it's a periodic tenancy agreement, it depends on your tenancy agreement as well. If your tenancy agreement says that upon it turns into a periodic tenancy agreement, notice of 2 weeks from the landlord, let's say, that in that circumstances, yes, you can actually still evict the tenant even after they file a complaint, because that is just your general right in the agreement that you're allowed to actually issue a notice and to kick them out. But without such notice, it is okay for a landlord to sort of write to the tenant and give them a notice to quit, because periodic tenancy means it's not their rights are not protected as well. So you can issue a notice for them to quit as well. But yeah, I think you really have to identify what's the mistake, because if the mistake is very great, I'm not sure what mistake, either environment or HMO. I could think of these two usually from council. But yeah, it really depends. Okay, David, if I ask you to provide an exclusive tenancy or license agreement, how much would it cost? This question, I think we will answer you separately after for the cost, because it's not my department. Drafting, apologies, because drafting agreement will be done by another department in my firm, because I only deal with litigation. I hope that answers your question. Anyone else with any other question? Shannon, can you take note of David's contact details? I think we can ask someone to reply, David.
Yeah, sure. I will talk to David.
Okay,
yep.
Perfect. Yeah, I just asked Shannon to write down your contact, and she should actually pass it on to me later. Yes, you can have my contact details. Shannon, I think my contact details, I'm not quite sure. Are you going to share it with the people in the talk today, or?
Yeah. Do you want to scroll to the next slide? I think there are some contact details.
Oh, is it this one?
Is it? Right, so this is our social media channels. You all can reach us out on any of these channels here, or alternatively, remember the slide where you have your name card on it, like this.
Yeah, so it's going to be this one. So it's going to be this. This is my name card. I'm sorry, someone scribbled on our slide, which I can't sort of change it. But yes, that is my name card. Any problem, you can actually reach me at my email address. Yep, or the info@lisaslow.co.uk, either. So any other questions? Maybe we will be mostly running a Chinese one if required, but yeah, for today it will be an English talk. So if Shannon, have you been getting any direct messages?
No, that's it.
Okay, that's it. Okay, everyone, thank you for your time. It's we ended 2 minutes earlier than expected. But yes, thank you very much for everyone's attendance today. Any question, feel free to ask us. I mean, we are always happy to help. Okay, thank you.